good to see you here today, especially given the circumstances. And for those who are seeing it on video, thanks for taking the time to watch. So we'll cover today the way in which effective workplace investigations can be conducted. The matters that we'll address as we go through are set out on this slide. So what is a workplace investigation and when should it be undertaken? When should in-house counsel become involved, as distinct from allowing the investigation to be conducted by others in the business or externally? The life cycle of a typical workplace investigation. We'll look at both planning a workplace investigation to ensure that it's structured the right way from the beginning, and then conducting the investigation, reaching a sound conclusion, the sort of considerations you should have regard to in that process, finalising the report. Legal professional privilege, we'll focus specifically on that, and one of the key messages that I'll provide in that regard is that privilege can't be retrofitted to an investigation. You've got to make a decision about that up front, and so that's an issue that needs to be considered right at the beginning of the process. Legal and practical issues, pitfalls, traps, and practical tips. So that's the plan. Let's see how we get on. So what's a workplace investigation? Typically, it's an inquiry into allegations about conduct or culture in a workplace. Sometimes it strays from that. I've certainly done a number of culture investigations, also organisation design, a concern within the business, for example, that the structure of the business is not working effectively, which can lead to an external investigation with the benefit of the independence that comes from having someone with fresh eyes look at whether the structure that exists is working, or at least gathering the views of people in the business as to whether the structure is working. But in any event, it's obviously enough. It's about looking into the business either in respect of conduct or culture, or sometimes other things. Generally, an investigation will follow from a complaint that's been made or some other issue that's been raised. Lots of different ways in which that process can be initiated. We're certainly seeing an increase following the changes to the Corporations Act recently in whistleblower investigations, which are often made anonymously, sometimes not, but often made anonymously. And of course there are special protections that attach to disclosures of information within that whistleblower regime. And so not only is that an increasing source of complaints that lead to investigations or that require investigation, but when those investigations happen, they need to happen within the requirements of those whistleblower protections, including in particular ensuring that the identity of the disclosure is not revealed through the process, and that no action is taken against the disclosure because of the fact of disclosing a matter which is believed to be legitimate. Workplace investigations can arise from external complaints, and some examples there from a regulator, from a union or a customer. I began my career working for a trade union, and I remember I ran an unfair dismissal case for them involving someone who worked on the Harbour Bridge, painting the Harbour Bridge, who was spotted by a passerby having a sleep in the work area on the Harbour Bridge rather than paintbrush in hand doing his job. The punter who walked past took a photo, sent it in and said something should happen to this guy, and he was sacked. So complaints can come from anywhere. And so that's, I guess, what the final dot point there is about. What did I do? Anonymous complaints raise... I'm sorry, have I... No, that's good. Anonymous complaints raise particular issues. I mentioned already that often whistleblower complaints are anonymous. Whether they're whistleblower complaints or not, it's always been possible for issues to be raised anonymously, whether it's a letter left in somebody's pigeonhole, an email that's sent from an untraceable Gmail address or whatever. These have always been a feature of the process. The challenge is that normally, in order to understand the nature of the allegation, the full context, and to appreciate what needs to be done in response to it, it's normally necessary to go back to the person who's raising the issue and ask some questions. And when it's an anonymous complaint, a complaint that you just don't know where it's from, you're not able to do that. And so the question as an investigator or as a business receiving these complaints will be whether you have enough information to initiate an investigation. If all it is to say that person X is a bad guy and nobody in the work group likes him, then there's probably not enough to investigate without conducting a royal commission into person X, which will be disruptive and potentially quite unfair. So at one end of the spectrum, you might decide not to investigate, but you might have enough information. So questions there, are the allegations sufficiently clear and precise to be understood? Can the allegations be independently verified? Now, if they're clear enough, you can probably verify them by independent sources, but maybe not. Maybe they relate to just an exchange between two people that wasn't witnessed by another person, so that may not be possible. Thirdly, can the employer provide evidence to a court or tribunal to support a dismissal? So if all you've got is the anonymous complaint, then you're probably not going to have enough to ground any ultimate decision. Ultimately, when you're investigating something, you need to know the where, the when, the who, the what of the thing that's alleged. And if you can't go back to the complainant to clarify those things, it may be that the process stops there. Obviously very situation specific. Preliminary issues for investigation. I'd actually put these in a slightly different order. I'd start with what internal policies apply, the second dot point, because let's look at what rules the employer has set for itself in relation to this sort of situation. I know from when I was way back at the beginning working for the union that the first thing I did in an unfair dismissal case was to ask for any policies that existed in relation to the particular type of conduct that existed, or for investigating matters or conducting any sort of grievance process, because there was always some failure to adhere to the policy, and all of a sudden you had a foothold to an argument. And so the same thing applies in relation to an investigation. What does the company itself say should be the process, and how can you ensure that you comply with that? Now, I would caution against any sort of policy which restricts the investigation process. You want to have flexibility to deal with the matters that arise in whatever way is appropriate in the circumstances. So you don't want a policy that says, this is the way we investigate things here, step 1, step 2, step 3, because there'll be circumstances where that's simply not appropriate. You might have some broad considerations around fairness, around opportunity to respond, around considering all available evidence, around maintaining confidentiality where appropriate, where possible, but you don't want to have prescriptive steps in any policy. So I would say step 1 is take stock of what the relevant rules are within the organisation that's the subject of the investigation. Then let's go back up to the top. Should an employee be suspended pending the investigation? Argument in favour is that you don't want that person in the business potentially interacting with individuals who might be witnesses or having access to information that might be relevant to the investigation. So there's an interest in keeping the investigation material clean, separate from that person. Flip side is that that person is not guilty at the beginning of the process. They'll feel very much that they're being treated as guilty if they're being asked to leave the business at the beginning of the process. That would be very disruptive for them. It'll make it very public that the investigation's going on, and often you want to maintain business as usual while the investigation's continuing, and so you want to reduce as much as possible that focus on the investigation. And it may be unnecessary to ask the person not to be available. You may have already gathered the information that is available, and the risk of interference with the evidence is potentially fairly low. Next issue, should the matter be reported to the police or a regulator? In New South Wales, if an individual is aware of matters that would constitute the commission of a serious indictable offence, which is an offence that would lead to imprisonment of 5 years or more, potentially, then then there's an obligation to report matters to the police, and others may have obligations in relation to regulators in respect of the things that are regulated by them. So a matter to consider is whether the allegations that are made, especially when you're dealing with some sort of financial impropriety, inappropriate conduct in relation to customers, then there may be an obligation to report. Should information and data be imaged or protected or stored? Depends on what you're investigating. If it's about what was said by one person to another at a social function, probably not. But there seem in just about every situation that I come across, there seems to be some form of text messages, emails, WhatsApp messages that are relevant to the situation, what was said before, what was said after, blah, blah, blah. So generally there'll be something out there that you want to secure, and clearly you want to secure that right at the beginning. It's desirable for that to be done by someone whose speciality is securing that sort of information. And generally it'll be done by taking an image of the device on which that material is accessed. And that image of the device, whether it's a laptop or a phone, will be kept and effectively sealed so that it can't be tampered with. So you have a snapshot at a point in time of what was on the device when the image was taken. You can have a second copy of that, and then you can use that second copy to do all of the searching and so forth that you need to do. But you want to have an intact, untampered with record of that material. In some confidential information cases, for example, where the allegation might be that the individual sent information, whatever it is, plans or diagrams or data files or whatever, to themselves, what you want to present to the court is that intact file and be able to get an affidavit from the person who took the image to say, I'm X, I work at Ferrier Hodgson or whoever it is, my job is to do this sort of stuff, I did it here, the file attached was sourced from the computer, and here's what it says. You want that sort of really clear chain of custody and certainty that you've got an untampered file. Should the alleged perpetrator be removed from access to the systems, return their laptop, etc.? That's a bit like that first question around should you suspend them from work pending the investigation. It really is a circumstantial situation as to whether that's appropriate or not. In lots of bullying and harassment situations, for example, you would not take that step. But if you think there's an imminent threat arising from that person interacting with someone, then you might be a bit more interventionist. Public relations assistance, such as engaging a PR firm, preparing comms, etc. Again, very situation specific, but if you're sitting on a big chunky situation that you think people are likely to be interested in, then I think it's sensible at least to have a crisis plan in relation to comms, so that if you get the call from the Sydney Morning Herald saying we've just had a report of X and we're going to run a story this afternoon, you want to be ready to say something rather than scrabbling around doing that under the time pressure that they'll give you. So making the choice to investigate, this slide is all around what other options are there beyond investigating. So employers will always have a range of complaint handling and dispute resolution mechanisms available, and workplace investigations is one of them, but it's only one of them. Workplace investigations inevitably become the focus of attention within the workplace. People know it's happening. Individuals need to absent themselves from work for a period so that they can sit in a room either in the premises of the business or go up to the lawyer's office or wherever it's being conducted. And that needs an explanation. People become wise to what's going on pretty quickly. So that's disruptive. Also, the impact on the individuals involved is always very real. Even if there are no allegations against an individual and all that's happening is they're being asked to give their observations of a particular event, people find it stressful. The question and answer, they're sitting opposite each other at a desk, is impacting on them. So it's not necessarily the first port of call. There are a range of other options available to employers. If all that's involved at the outset of the process is an allegation that a person is acting in a way that somebody else finds unsettling or disrespectful, then it may be that some form of counselling, some form of just meeting the two people separately, possibly bringing them together, explaining why what one person is doing is having an impact on another, that might sort it out. Sometimes a formal mediation process is adopted, and some of my clients have done this where they've tried to settle it informally. The parties are sort of locked in a bit of a contest with each other, and rather than run a process which will lead to a winner and a loser, that the allegations are made out or not, they'd get them in a room with a trained mediator and try and work out what the real underlying issues are and resolve them. So there are a range of options that can be adopted, and so this is all about just pause before you press the investigations button and think about whether there are other avenues that might be appropriate. So what are the reasons why it might be appropriate to conduct an investigation? What are the circumstances that commonly justify that decision? Well, if there are serious allegations, if somebody's raising a concern that there's a safety issue, and it might be a physical safety issue, or it might be a bullying and harassment issue which is impacting seriously on people in the workplace, you've got to get to the bottom of it. You've got to work out if things are happening that shouldn't be happening. And so to consider serious allegations, it may be necessary as part of your risk management exercise within the business. You'll want to avoid liability for things that might be happening in the business. You've got to nip them in the bud, so you've got to work out whether they're happening. So sexual harassment and bullying are a couple examples of that. If the allegations appear likely to justify termination, but you've got to get to the bottom of them first, of course, then an investigation will allow you to do that. Health and safety risks I've mentioned. Ensuring workplace standards are maintained. Sometimes a part of the reason for having an investigation is to demonstrate to the relevant workforce that the policies of the business will be enforced, and that where things start happening outside the range of acceptable behaviour, that action will be taken. And so sometimes, yes, it's to get to the bottom of the specific allegations, but also it creates a broader awareness of the importance of adhering to the requirements of the business by demonstrating that action will be taken. Sometimes policies might require investigations to be undertaken, or contracts might require an employer to address issues if they arise, and the ever-present PR concerns. It seems that the bigger the company is, the more concerned it is about reputation, and often it's necessary just to ensure that there's a process there so that any decision that's ultimately taken can be defended, not just legally, but also in the world of public opinion. So if you've decided that it's appropriate to conduct an investigation, the next issue is to determine what type of expertise you need to conduct the investigation. There are a number of options, and there are a few set out here. In-house options are often very effective. It's less confrontational for people involved if they're being investigated by an HR person, for example, than by an external lawyer, so that can be appropriate. But then the flip side is that the internal HR person might know all of the parties in the investigation and might be seen not to be independent from all of them, and so it might be that an in-house person is not appropriate. Sometimes, rather than it being an HR person, you might get senior management. I've got some clients who've used their CFO, for example, or people in the finance function to conduct an investigation, which can be appropriate, particularly in circumstances where there might be some financial element to the allegations. If there's an allegation of fraud or mishandling of client money in the context of a health business, for example, where there might be individuals whose financial affairs are managed in part by the employees of the business who are caring for them, then it might be that a senior finance person is an appropriate person to do that. Or, of course, in-house counsel might be an appropriate person to conduct an investigation. Lawyers, obviously, external investigators. There are plenty of investigation firms that do nothing but investigations, and some of them do nothing but workplace investigations. Sometimes they have ex-police, other times they have people who have different expertise, but that might be suitable where you don't need the need to have a lawyer running the process. Some of the things to think about when you're deciding who might be a suitable investigator. First, the need for objectivity. I've had a situation in the last few weeks where a client which runs a business principally based in Sydney but with a smaller Melbourne office had allegations of bullying between some of the Melbourne people. The only real contenders for running an investigation into who's doing what to who were some of the Sydney HR people, but the Sydney HR people knew all of the Melbourne staff, including the person who was making the allegations and the person against whom the allegations were made, and they were just not an appropriate choice to run that investigation, because each of the key contenders would have been concerned that there was an allegiance owed to the other one. So the need for objectivity, often described as the need for independence of the investigator, is really important, and that might be an argument in favour of an external person, either an external lawyer or an external investigator. The skills of a good investigator. I mean, it's trite to say that somebody who's doing a job should be good at the job that they're doing, but in this case, there's a whole lot of stuff you need to be able to do in order to effectively investigate. In the first instance, generally, you want to put the person you're talking to at ease. You want to be able to get the conversation flowing, and so you need to have the ability to talk to people in a way that allows them to relax. You need to be able to identify the things that you're looking for, but not necessarily signal that you're looking for them. You want those things to come up naturally in the conversation. You need to understand, the reference there to good listener, I think, is important, because you need to be reading the person that you're interviewing in order to determine how best to go about raising the issues, what's likely to ensure that they're giving you a continuing flow of answers and the answers are as reliable as they can be. And so to do that, you've got to be listening closely to what they're saying and how they're responding. You need ultimately to have, as your sort of true north in the process, an ever-present focus on the allegations that you're investigating. Why are you having this conversation with this person? What are the things that you're likely to get from this person? How do you get to those topics? Do you just launch straight into them, or do you let the conversation get there of its own volition? Do you raise general matters and allow them to respond? So, an example, I recently conducted an investigation that was about leadership and culture within a work group. It was based on some allegations that were made that a particular individual was doing the wrong thing in various ways. But I didn't want to say to all of these people I was interviewing, the allegation is that this person's doing the wrong thing in particular ways. I wanted to hear it from them as to what they were experiencing, so that what I got from them was not a yes-no of what I was putting to them, but rather their own individual view of what was good and what was bad in the workplace. So rather than ask about the allegation, I asked about workplace conduct and behaviour and allowed them to tell me whatever they wanted to tell me. And inevitably, they got around to the issue that the investigation had been generated from, but they did it in their own time without me leading them there, and they then expressed the issue in their own language rather than adopting any sort of language that I used in putting a specific question. And that, to me, gave me a much more reliable source of information, because what I was getting was what they genuinely thought rather than them just agreeing or disagreeing to what I was putting. Next, capacity to devote the time required, with the note that long investigations are often bad investigations. In my experience, businesses always want investigations dealt with quickly, unless there's some sort of weird external circumstance where they want to drag it out, which I frankly don't encounter much, because that's really in the game playing territory, I think, rather than a legitimate interest. Certainly the person who's being investigated wants it done and dusted. Tell me the outcome one way or the other, but just end the pain. The people involved want to get into their interviews and then get out of them and be done. The business wants the disruption to end so that everybody can get back to business rather than focusing on this sideshow. Generally you want to get in and do it as quickly as possible. Increasingly, and in the coronavirus world that we're living in now, this is particularly relevant. Increasingly, interviews are conducted by phone rather than in person. And whilst it's not as effective from the perspective of forming a view about what the person's telling you and how reliable they are, it's still pretty good. And it allows the investigation to flow much more quickly. So rather than everybody having to be in a room at a particular time, it's just a whole lot easier to set stuff up, a whole lot easier to run on if there's a bit more to talk about. And the desire to knock it over quickly generally means that as a trade-off, it's preferred. Video conference is possible, but even that level of additional technology seems to pose a bit more of a challenge to setting stuff up. You've got to have the people at opposite ends on the same platform, and so it tends to be, in my experience, either in person or phone. The need for the outcome to be respected by the participants. I think a lot of my clients get comfort from knowing that they can say to the relevant stakeholders, we had an external process conducted by lawyers who do this sort of thing, and we're confident in the process that they've conducted and the outcome that they've reached. For the independence reasons I've touched on before about how in-house people typically have some relationship with someone involved in the process, I think that independence factors strongly or weighs strongly in favour of an external process, particularly by reference to that consideration of the need for the outcome to be respected by the participants. So this is just a sort of summary cheat sheet about pros and cons of internal versus external. So just very quickly, internal, you can retain a bit more control over the process if that's what you want to do. Although if it's a fact gathering process, you probably just want to gather facts. So clear over control is really what you should be about. External independence, I think, is a key advantage. Internal, having knowledge of business processes and objectives. Sometimes, so I've got an investigation at the moment where we're looking at the processes around employees managing cash for clients in a health business. And it would actually be useful to have someone who knows what those processes are and how they work in a practical sense. Now, we can learn that, and we do that by talking to people and looking at documents, but there might be people in the business who'd have a bit of a jump on us in that regard. By comparison, external, the specialist skills and expertise, so I've done many more investigations than anyone in the business would have done, so yeah, you've got that trade-off. Internal, easier to manage the cultural impact of the process if you're the HR manager or the in-house counsel who knows the way things work in your business. External, maybe perceived to be more credible. I don't know, credible, independent, certainly, I think. Internal, generally quicker and cheaper, yes. External, it's less open to challenge. So anyway, just some considerations to have regard to. Privilege. So I mentioned before that you can't retrofit privilege to an investigation. You've got to either set it up for the dominant purpose of obtaining advice or in preparation for the conduct of litigation or not. And so before any documents are created, you should consider this issue. It is a dominant purpose test, and I suspect everybody here understands what that means, but just to be clear, that doesn't mean, or that test won't be satisfied if there are a number of important purposes and none of them is more important than the other. You've got to have the relevant purpose, legal advice or litigation, being the key reason, the dominant reason, the reason that is more important than any other reason in order to attract privilege. And so if you're getting an external investigator, for example, so take a classic case of a personal injury matter where you want an investigator to determine whether the person who claims to have a bad leg is playing soccer on the weekend. The lawyers engage the investigator conducts the investigation for the purpose of giving it to the lawyers so that they can run the litigation, clearly privileged. If you've got an in-house lawyer who's investigating an allegation of bullying, and the output of that investigation will be used to provide advice about rights, but will also be used to determine whether the allegations are made out and whether that person should be sacked. That's a bit more line ball, because you've got a series of considerations, and which of them is dominant, or are any of them dominant, will be an open question, or a question where the answer is not as clear. So the issue to have front of mind, and it will vary situation by situation, but the issue is one that you need to turn your mind to at the beginning. What is the dominant purpose of this investigation being conducted? If it's to enable lawyers to give legal advice, and that's the reason you're getting the investigation, great. But if it's for a number of different purposes, to work out whether we need to restructure this organisation because X doesn't get on with Y, or because the processes don't work for some reason, as well as to get legal advice, then you're in a grey zone where you'd need to really pause and think, are we going to structure this in a particular way to achieve an objective, or do you accept that this really isn't a privileged exercise and we're not going to persist in trying to treat it as privileged? I've mentioned that final dot point about it, engaging a third-party investigator with the personal injury example that I've given. Setting the parameters for the investigation to commence, and then so the threshold issue is the privilege one that we've just touched on. Next, is it a formal investigation or an informal investigation? Even though I'm an external party to my clients, I've in recent times quite often been engaged to conduct investigations that are quite informal. And one of them was initiated by a complaint about bullying, but ultimately was conducted as a review of culture and behaviour in the workplace, where HR set it up, HR at the client, and they arranged for us to talk to 5 people on the basis that we were conducting a review of culture and behaviour in that particular work area. And we got lawyers to do it because or the HR person told people in the business that they got lawyers to do it because they want someone independent to the business to just gather some thoughts and feed that back into management. So that was quite an informal conversation, which started with me saying, yes, I'm a lawyer, but what I'm talking to you about is really just your impressions of what works and what doesn't in the workplace. And we had a casual conversation. Terms of reference. It's important for the investigator to know a few things. What's the scope of what they're supposed to be looking at? Is that fixed, or is it going to change during the life of the investigation? You can imagine that if there's widespread misbehaviour of some sort in a business, the allegation that initially raises concerns might relate to one thing, but by the time you've spoken to the first 2 or 3 witnesses, they may have raised similar allegations in relation to other people. They may have cross-allegations back against the person who made the complaint in the first place, and all of a sudden what started as a fairly confined issue has grown a number of different heads, and there's a decision to be made about whether the investigation, which started on a narrow footing, should expand or should be kept to that narrow footing. That's something for the terms of reference to determine at the outset of the process, but then to return to as you're going through the process and determine, do you stick to the original plan or do you broaden it out? Ultimately, another thing to deal with in the terms of reference is the role of the investigator. Is it just a factual investigation to determine whether certain things as alleged happened, or is it also intended to make recommendations or conclusions as to whether those facts constitute bullying and harassment, for example, whether they would warrant termination of employment? Is that something that the investigator is being asked to do? or is the investigator just determining the factual matters and handing those to a decision maker who then will take on that process of determining what flows from the factual findings? Really important to be clear about those things up front so that you don't end up writing a report that nobody wants that says that we recommend you do X and Y when nobody wants to do X and Y, and they never wanted to hear from you on those topics in any event. Generally, in the terms of reference, you will have some form of allegations, and ultimately the allegations will form the skeleton of the investigation process because they sort of define what you're looking at. But for the reasons I've already explained, those allegations may grow or shrink during the course of the process. Last year I had a whistleblower investigation where there were allegations of bullying and harassment, but also allegations of improper claiming of expenses and kickbacks. And there was no evidence in any of the interviews that we had of the kickback allegations. And so ultimately, as we went through the process, we dropped that because there was just nothing to support it. It was an unfounded allegation with no evidentiary basis. So that's an example of allegations dropping off. But as I mentioned, allegations can find their way on as well. The bottom dot point there, findings of fact and whether conduct is a breach of policy, recommendations for an employer's response. So let's imagine a situation where somebody says something at a social function that other people take offence to. Might be a race-based comment or a sexual comment. The business that you're working for, that you're doing this investigation for, might want you to express a view about whether that constitutes a breach of the code of conduct, or they might not want you to express that view. So again, important to be clear on that. Ultimately, in these sort of civil investigations, so not criminal, the test is going to be a balance of probabilities test. And so my preferred way of looking at that is in the second dot point. Is it more probable than not that the alleged event occurred? I think the 51%, some people find that useful, but I can never really quantify the likelihood of something in precise percentages, and so I prefer the more probable than not. When you're considering this, many of you will be familiar with the Briginshaw standard, which is a reference back to a case that said that essentially, yes, for civil matters, the balance of probabilities will be the relevant test, but as the nature and seriousness of the allegations goes up, so too does the need for evidence to prove that the allegations have been made out. And so if the allegation is a relatively trivial matter as to whether person X was at a location at a particular time or something of that kind, then the evidence you need to establish that, to find that that's been made out on the balance of probabilities, might be relatively low. But if the allegation is whether a person touched another person in a particular way at a particular time, understanding that that will have significant ramifications as to what that might amount to, then you might need more proof to find that that's been made out. It's a curly sort of concept, but one to bear in mind that you can't lightly come to a conclusion, even on a balance of probabilities test, if the matter that you're coming to a conclusion on is a serious matter. You've really got to do the best you can to try and exhaust the available evidence to reach the conclusion. Golden rule, use a procedurally fair process. I even talk to my clients in terms of the process and say we've got to trust the process. We've got to let the process run its course in order to determine the outcome. We can't know today what the outcome's going to be. We can't try and structure it in a particular way to achieve an outcome. We've got to run the process, run it properly. That's why you're engaging us, so that we can do it in a proper, fair, independent manner. Trust the process and reach the outcome that you reach. The first dot point there refers to ensuring you have allegations that are well particularised from the outset and that are clearly articulated. This is fundamental to any sort of natural justice, that the person against whom allegations are made is aware of what those allegations are and ultimately has an opportunity to respond. Allegations, or framing the allegations, is something that requires a fair bit of thought. It can be done well or badly and can have a significant impact on the process. Ideally, we want allegations that are short and simple and go to factual matters, and that only get to conclusions right at the end of the process. So if you're looking into allegations of sexual harassment, for example, then your allegations might start with an allegation that you were present at the Christmas party at the station hotel on a date. That's the allegation. That's number one. Section 2, that you had a conversation with the complainant. That's allegation 2. Allegation 3, that in the course of that conversation you said words to the effect of blah, blah, blah. You break it down like that. You don't run those things together and have them as a single allegation, because then you end up making findings in relation to part of the allegation but not the other parts that create a confused outcome. So the individual, you might find that allegation 1 is not made out as to section 3, which says this, but is made out as to the first and second sections, which becomes very confusing. You want to break it down into the factual elements that comprise the matter that's being complained of, so that you can have crisp, clean findings in relation to each of those elements. And these allegations become the skeleton of the report that you ultimately produce, because these are the things you report on. You say, we found that he was there at the station hotel, that they did have a conversation, and either you find that the conversation did include those words or did not include those words, or there's insufficient evidence to make any conclusion as to whether it included those words. That type of finding, so that there's real precision and clarity around both what's alleged, but also as to what's made out. And if you get it wrong at the outset and you've got some confused allegations that don't make sense or that have too many intertwined issues, then your ability to come to good, clean findings that might warrant action is compromised. So it's one of those things where you get the foundations right and then you sort of build the process from there. It's important for people to know where they're at in the process. A workplace investigation I ran last year ran for about 6 weeks before we had our first conversation with the person against whom the allegations had been made. But it was necessary for him to be told about the process, because we spoke to 15 of his people before we got to him, so that we could understand all of the allegations and put some allegations in a proper form to him. So we had an initial conversation, which was, the investigation's happening. This is what it's going to look like. We're going to talk to a number of people. We'll come to you when we're ready. We anticipate that'll be in a certain period of time. And then we set out the expectations as to confidentiality and not taking action against people or talking about it, whatever. And then when we had spoken to the others, we were able to frame up the allegations, put those to him, give him an opportunity to think about them, determine how he wanted to respond, and then get him in and have a conversation. But so he knew throughout the process where we were at, and that is it's as much a matter of kindness as it is a matter of fairness. But if some big ugly process like this is happening and you're involved in it, you want to know where you're at in relation to it. As for giving an opportunity to respond, the opportunity needs to be fair. That's obvious, but what does that mean in practical terms? You need to give enough time for the individual to think about their response, and that might mean that you propose a time but invite them to tell you if they think that's not enough. If there's 100 allegations, giving them 2 days is not going to be enough. You also want to let them respond in the way that they want to respond. And this is my personal view. Others have a bit more of a sort of prescriptive view, but if someone wants to respond in writing, great, thanks. We'll have that written response. Happy to look at that. If they want to respond in a meeting, happy to do that too. If you want to do both, that's fine too. We'll hear from you in hieroglyphics if you want. I don't care what form you want to respond. In taking that approach, you remove from anyone the opportunity of saying, well, I was forced to respond in a way that was unfair, that wasn't reasonable. Collect and consider all relevant evidence. keep the investigation independent and impartial, maintain confidentiality where practical. It's not always possible to maintain confidentiality. When the allegations, particularly in a workplace investigation, involve allegations of conversations, there may be very limited people who would have witnessed the conversations, and by raising the conversation you're almost automatically disclosing who it is who's raised it. That may be necessary, but it's something to be avoided where possible as a general principle. Meet the necessary standard of proof, make a decision as to whether the allegations are proven. So that's all good procedural stuff. Conducting the investigation, ideally investigate the complainant first, although if it's anonymous you won't be able to do that. Identify relevant witnesses. That's where you sort of fill in the gaps and get a better, broader contextual understanding. Things might grow or shrink at that stage. Determine and preserve other sources of evidence. You've probably done that right at the beginning when you've taken an image of the computer and locked people out of any files, folders, accounts, etc. that they shouldn't have access to. Determine the process and the order of witnesses. Normally that involves having the respondent coming last. Conduct the interviews and gather the evidence. Give everyone an opportunity to respond to any contradictory evidence. So if somebody's telling you that a certain thing happened a certain way and you're asking others about that event, you need to give them an opportunity to respond to that. Whether you say person X said it happened this way, what do you say to that? Or whether you simply ask them for their explanation as to what happened. That'll be a judgment call for the investigator. Evaluate, make a finding. The third last dot point there, the statement should be in the witness's words, not the investigator's words. 2 points there. Firstly, I don't tend to produce a statement which I ask people to sign. I tend to just rely on my notes. I'll normally have a colleague, might be a solicitor from here, might be someone from the client who I'd run the investigations with. And I think we take our notes and we feel reasonably comfortable that they're accurate. But the second point, if someone uses a particular set of words to describe a situation or how they feel or recall something, I try to get those words. I don't take a verbatim statement, but there's always a few key issues that people respond to in a particular way. You know, there's no way known I would have said that. I'd write that down because that's authentically their language in dealing with the allegation. He was as drunk as a skunk. Yeah, you write that down because you want to get the evidence in the form that it's given to you, not in your paraphrase. And you've probably all seen those reports of judgments where the judge has said that the affidavit looked like it was written by a solicitor when it was written by a solicitor, but you want it to look like it was written by the person who's deposing it because it's their affidavit. And when you put those sorts of words in, it helps enormously. Making the decision, you've got a range of options as to how you determine the allegations. Normally it's some form of made out or not made out or insufficient evidence to make it out. That's the finding. But in a report that you're preparing for a client, you'll be wanting to provide some explanation as to the basis on which you've reached that conclusion. It might be, for example, that you've interviewed 8 people, 6 of them gave evidence on this particular point, 5 of them said one thing and 1 of them said the other. In the report, I'd be providing that level of detail in order to ensure that the decision maker understands that there might be one dissenting voice, for example. Whether you categorise the findings as unlawful or a breach of a policy or a code or unreasonable or unprofessional conduct, that is something to have been determined when you were setting up the terms of reference. Is that what you're being asked to do, to express a view on whether a policy has been breached, or are you simply making factual findings? You don't want to be told that at the end of the process. You want to know that from the outset. Writing a good report. Well set out, logical, yes. Terms of reference, yes. You want the report to set out the process that you followed and the conclusions you've reached. The process that you followed will be straightforward. we received a complaint on a date, we determined that we needed to speak to these people, we spoke to them on these dates, we obtained this other evidence, which was from emails, WhatsApp messages, whatever. We put it all to the respondent, met with her on a certain date, and we've reached the conclusions we've reached below. Like that type of very factual, what we've done in the investigation. As to the conclusions in relation to the allegations again are the skeleton. They're the thing that you're investigating, and they're the thing you're reporting on, and so the report needs to be structured by reference to them. So there should, I mean, as simple as this, you want a heading that says allegation 1, set out what it is. Our finding here is blah. Reasoning, set it out. Sounds obvious, but often people get sort of distracted by noise around the edges, and I think it's really useful to bring it back to the skeleton, which is the allegations. Some good tips there. Mark it strictly private and confidential, particularly if you want it to be privileged, because it will only be privileged if confidentiality is maintained. Start with the terms of reference and scope. I've touched on that. Summarise the process, key allegations and conclusions. Yep, so we've dealt with all of that. I normally make clear that we've determined the factual findings on the balance of probabilities. I think it's good for the reader of the report to know that that's the approach you've taken and to understand what that means. And I normally express it in terms of more likely than not. Recommendations only if required. Annex all the relevant material. That for me is a question mark. Do you want to have everything attached to the report, bearing in mind that the report might do the rounds of a group of people in the business and so on? Or do you want the report to be the report and other materials available if it's required? That depends on what the material is, what the volume of it is, how sensitive it is. Sometimes it can be inflammatory, sometimes it can be as boring as can be and nobody really wants to look at it. So yeah, those are all factors to bear in mind. Communicating with stakeholders, you'll tell different people different things, not inconsistent things, but different levels of information. So it may be that the complainant is told simply that the investigation has now concluded and to the extent required, action has been taken to address the issues that they've raised. You may not say, and we found that the managing director did do blah, 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 because it may be that there's no interest, there's no legitimate interest for the for that information to be disclosed to the complainant. For the respondent, you will normally tell them that which allegations are made out and which allegations are not made out. You'll probably give them less information about who said what about each of those allegations because they've had their say in the process, and all you're doing is delivering the outcome of the process, and that doesn't mean opening up the hood and showing them everything that went into the process. Witnesses will probably not be told much at all. They may be told that it's concluded, but often not much more than that. And others in the workplace, you may want to give people sort of the all clear that the process is now done and please all, resume normal broadcast operations, because it will have been a distracting process. And then finally, we'll just touch on resolution activities. So what's the outcome of the process? Well, this will be determined by the decision maker, who is probably not the investigator, and can be a whole range of stuff, from disciplinary action to counselling, an apology, internal changes to policies, a whole range of stuff, and can result in a number of different changes. So one of the investigations I ran last year resulted in a warning being issued to the respondent because there were findings against him, resulted in no progression to the next position up the tree that he was otherwise potentially being considered for, no bonus because of the finding. So there was a remuneration outcome, a progression outcome, a warning, and counselling. So it can result in a number of different responses. And there are key takeaways, which are essentially a restatement of what we've touched on, so I won't go through those in any detail. I'm out of time, pretty much. I've got a couple of minutes, I think, until 2:30, but I'm happy to take any questions, if there are any questions in the room. Hi.
When you're informing the respondent about the outcomes, do you need to give them the details about where the allegation was made out?
So the question for the camera is whether there's a need to give the respondent more information about the basis on which conclusions were reached that the allegation was made out. There's not an obligation to do that. If there's a factual finding against them, then there'd probably be a secondary process at that point where you say, and on that basis we're considering issuing you with a warning or terminating your employment or something else. Give us your response to that. We're consulting with you on that, and we want to hear what you have to say on that before we make a final decision. And in that context, you need to give them the information that's necessary for them to be able to respond. Now, what that amounts to in a particular case is a matter of judgment. But I would, in the world that we live in now, where there's such a concern about ensuring that people who've participated properly in this sort of process not being victimised for their participation, generally you would not say, X said this and Y said that, and so on that basis we've concluded as follows. You'd provide them with some abstracted version of that, some summarised version at most, and possibly not even that. Possibly you would just find, we found that you did say those words at the station hotel at the event that we've referred to. Yeah. Yeah, so how to feed back to the complainant the outcome that's been reached. And I don't mean to appear like I'm ducking the question, but it really is very situation specific. If, for example, it's two employees who work closely together and there's going to be a change in those arrangements as a result of the conclusions that have been reached, I'm no longer reporting to X, then you would give them that information. If it's something less directly relevant to the individual, so for example, if there was an allegation that they were defrauding a customer, then it may be that you tell them that the allegations have been concluded, or that, the investigation's been concluded and that relevant action is being taken, but you may not tell them what their conclusions were on specific allegations. It may be that that's a level of detail about the independent employment arrangement between the employer and the respondent, which should not be disclosed to the complainant. So it's sort of, thank you for raising it, we've looked into it, we've now dealt with it, and appropriate action's been taken without any sort of further confirmation as to what the outcome was. The complainant might be unsatisfied by that, but there are competing considerations about the complainant's interest, just a natural human interest versus the respondent's expectation of sensitivity and privacy in relation to matters affecting the respondent's personal employment arrangement. So.
I was thinking more in relation to like complaints made around sexual harassment or and the finding made against that person, how much information you have to give.
Yeah, I think that's probably more in the first category I mentioned, where if it directly affects the individual, if it's an allegation of sexual harassment and it's found to have been made out and the person is dismissed, for example, then the fact of the dismissal will be public knowledge because that'll be disclosed. The trickier territory is normally if there's some sort of warning or other disciplinary outcome that's not termination, and there's no playbook on that. It's going to be a situation by situation, balancing those considerations of sensitivity versus expectation to know. And sometimes it's dealt with quite informally. Sometimes it's the individual might be informed what the outcome was, but on a confidential basis, for example, with the expectation that they won't disclose that more broadly. The employer has an interest in being very careful with that information because they can be vicariously liable, as well as not wanting to breach any duties they might owe to the respondent as well as to the complainant. So generally less is more, or less is more desirable anyway, generally. Okay. Thank you. Thank you. Thanks everyone.